Today I want to talk about the Second Amendment, and I want to do so in a somewhat limited way. Scholars and historians have argued and discussed the historical origins of the Second Amendment, the original purpose of the Second Amendment. And of course, policymakers and interest groups have argued and discussed how to regulate the Second Amendment and the right it provides. But today I want to talk about the Second Amendment from a purely legal perspective. And whenever I think about a legal issue, particularly a fundamental enumerated right, I like to think about it in terms of what the most important questions are surrounding that right, and then thinking through how many of those questions have been answered and whether the answers are in and of themselves satisfactory. When I think about the Second Amendment, I really think about it in terms of three fundamental questions. First, what is the nature of the right provided by the Second Amendment? Second, what is the breadth or extent of that right? And third, what is the framework through which we analyze the right in a legal case? Now, I'll tell you, from 1791 all the way up until 2008, the Supreme Court had answered none of those three fundamental questions. We got an answer to the first question in 2008. We got an answer to the second question in 2010. And today, in 2020, we still don't have an answer to the third question from the United States Supreme Court. And lower courts, while many of them have answered the question, can't agree on what the answer is. Let's talk about it. Prior to 2008, the District of Columbia effectively prohibited handguns. They passed a law that any handgun had to be registered, yet you couldn't register a handgun. They passed a law that the gun owner had to be licensed, yet licenses were temporary and hard to get. Even at home, the DC law said that handguns had to be rendered temporarily inoperable. So, DC police officer Dick Heller applied for a registration certificate, was denied, and ultimately sued the District of Columbia, which gave rise to the landmark case District of Columbia versus Heller. And it's this case in 2008 where the Supreme Court answered the first question, the first fundamental question, which is what is the nature of the right to bear arms under the Second Amendment? At the time, most courts had held that the Second Amendment right is a collective right that only protects possession of a firearm as it relates to service in a militia. In fact, at the time, the individual rights theory was by far the minority view among courts, holding that the Second Amendment provides a right to bear arms for any lawful purpose. In fact, at the time that Heller was decided in 2008, only one court, the Fifth Circuit, in a case called United States versus Emerson in 2001, had held that the right to bear arms under the Second Amendment is an individual right. Yet ultimately, the Supreme Court in DC versus Heller, written by Justice Scalia, held that the Second Amendment is an individual right. The opinion is very lengthy. It's an originalist tome that I won't recite here, but I encourage you to go read it for yourself. I will say that there are two important takeaways from the opinion. First, that the nature of the Second Amendment right is one of an individual right to bear arms for purposes of self-defense, particularly in the home. And second, and this is an important takeaway that sometimes gets missed, the opinion clearly recognizes room for states or the federal government to regulate the use of firearms consistent with the Second Amendment. And this can be found in Part 3 of the opinion, and I wanted to point to that because in the legal analysis, this becomes very, very important, particularly when, say, a criminal defendant, for example, is challenging the constitutionality of a firearms restriction. Here's what Justice Scalia says in Part 3. Like most rights, the right secured by the Second Amendment is not unlimited. From Blackstone through the 19th century cases, commentators and courts routinely explained that the right was not a right to keep and carry any weapon whatsoever, in any manner whatsoever, and for whatever purpose. In other words, it's not a libertarian carte blanche right. It is subject to some regulation. Justice Scalia enumerated a non-exhaustive list of 4 different ways that would be historically acceptable regulations on firearms. First, regulations against felons. Second, regulations on the mentally ill. Third, laws forbidding the carrying of firearms in sensitive places, such as schools or government buildings. And fourth, laws imposing conditions and qualifications on the commercial sale of firearms. So it's that illustrative list that becomes very, very important, not when we're talking about the nature of the right, because it is an individual right now, but later when we're thinking about the framework through which we're going to analyze that right. That's District of Columbia versus Heller, and that answers the first question. In 2010, the Supreme Court answered the second fundamental question about the Second Amendment, which is, what is the extent or breadth of the Second Amendment's right to bear arms? It came in a case called Mcdonald versus City of Chicago. There, the City of Chicago had passed a law very similar to the handgun ban passed by the District of Columbia, which the Supreme Court had struck down in Heller versus District of Columbia. But Chicago asserted that its law was indeed constitutional because it is not a federal enclave. In other words, the City of Chicago was making the argument that the Second Amendment did not apply to the states. Petitioners, represented by Mr. Mcdonald, made the contrary argument, that the Second Amendment applied to the states. Petitioners did so through 2 primary arguments. First, that it applied to the states through the Privileges and Immunities Clause of the 14th Amendment. And second, that it was incorporated to the states through the Due Process Clause of the 14th Amendment. The discussion in the opinion written by Justice Alito that follows is fascinating. Justice Alito looks very closely at the history of the Privileges and Immunities Clause, but ultimately declines to use that as the vehicle through which to incorporate the Second Amendment to the states because of the interpretation by the Supreme Court in the so-called slaughterhouse cases, which interpreted the Privileges and Immunities Clause very narrowly. Although Justice Alito, along with Justice Thomas, is very critical of that interpretation, Justice Alito quickly pivoted to the Due Process Clause and looked at different historical theories of incorporation, discussing, for example, Justice Black's view that all of the Bill of Rights, and perhaps more rights, should be incorporated to the states, but ultimately arrives at selective incorporation, which is the modern view of incorporation through the 14th Amendment. Through selective incorporation, an enumerated right will apply to the states if it meets one of 2 criteria. First, that it's fundamental to our scheme of ordered liberty and system of justice, or that it's deeply rooted in our nation's history and tradition. One of the most interesting parts of the opinion to me was footnote 13, and that's where Justice Alito describes the rights that have not been incorporated, at least not recognized as having been incorporated, into the states. Justice Alito says, in addition to the right to keep and bear arms and the Sixth Amendment's right to a unanimous jury verdict, I will note that you should look at our most recent breakdown 10 years after this opinion of Ramos versus Louisiana, which did change one of those. The only rights not fully incorporated are the Third Amendment's protection against quartering of soldiers, the Fifth Amendment's grand jury indictment requirement, the Seventh Amendment's right to a jury trial in civil cases, and the Eighth Amendment's prohibition on excessive fines. So other than this very short list, most all of the Bill of Rights and then aspects within them have met this one of the prongs of this requirement. In light of the work done by Justice Scalia in the Heller opinion, Justice Alito was able to answer this question fairly easily. Once it was recognized that the Second Amendment really represents an individual right to bear arms for purposes of self-defense of not only the person but the home, it became very easy to say that it is indeed fundamental to our system of ordered liberty. And then second, in light of Justice Scalia's originalist description of the Second Amendment, going all the way back to England, talking about Blackstone, for example, it was equally easy for Justice Alito to say that the Second Amendment is certainly deeply rooted in our nation's history and traditions. In doing so, it's important to note that Justice Alito wholesale rejected respondents' arguments by looking at foreign law to try to evaluate what ordered liberty requires. So it's in this case in 2010, Mcdonald versus City of Chicago, that the Supreme Court first held that the Second Amendment is incorporated into the states, and therefore its breadth and extent are incredibly large. But as we will see, it's the third question: what is the analytical framework through which we evaluate the Second Amendment, particularly challenges to statutes under the Second Amendment, that is the most difficult and the most complicated and is still yet to be answered by the Supreme Court. I now want to talk about the third and perhaps most difficult question. What is the analytical framework through which we evaluate the Second Amendment right to bear arms, particularly challenges to statutes that restrict that right? I know we spoke before about United States versus Emerson, which was before the Fifth Circuit in 2001. That was the only case before Heller in 2008 that it held that the Second Amendment right to bear arms is an individual rather than collective right. Using that as a jumping point, as a starting point, the issue in Emerson was the constitutionality of a firearms restriction found in the United States Code 18 U.S.C. section 922 G8. For those of you that practice federal criminal law or are familiar with firearms law, you'll know that federal law criminalizes 9 different classes of persons from possessing firearms. 922 G1, which is felon in possession of a firearm, all the way through 922 G9, which is misdemeanant of domestic violence in possession of a firearm. 922 G8 is somewhat related to G9. It was passed around the same time in 93 or 94, and it criminalizes possession of a firearm by anyone that has an active domestic violence protective order against them. So in 2001, someone was charged under 922 G8 in the Northern District of Texas and challenged the constitutionality of that provision in light of the Second Amendment. The district court actually dismissed the indictment on the basis that the Second Amendment right to bear arms is an individual right and is very, very strong and not subject to much regulation. On appeal, however, the Fifth Circuit reversed, doing an in-depth originalist review of the Second Amendment, but ultimately concluded, based on a somewhat amorphous balancing test, that 922 G8 withstands constitutional scrutiny. There was no real ascertainable or identifiable analytical framework put forth at Emerson. And it wasn't really until after Heller in 2008 that courts were really confronted with this problem. We know now universally it's an individual right. So like other kind of fundamental individual rights, how do we go about evaluating restrictions on that right? Well, most courts looked at Heller and saw that Heller made references to the First Amendment and other types of constitutional provisions. So perhaps that's why most circuits have borrowed or created a form of means-ends scrutiny when evaluating challenges under the Second Amendment. So we're talking about rational basis review, intermediate scrutiny, and strict scrutiny, just as we all learned about in constitutional law. So for example, in the Fifth Circuit, the court for the first time in 2012 in a case called NRA versus ATF looked at a challenge to a firearms regulation under the Second Amendment and sketched out this two-step framework for evaluating it. Of course, there we were dealing with a challenge to the age at which a person can purchase a firearm. And that had its own hurdles because that was one of the four kind of enumerated historical prohibitions from Heller itself. But nonetheless, in this NRA versus ATF case, the Fifth Circuit actually borrowed from another circuit this two-step analysis, asking first whether the regulation at issue regulates conduct that falls within the Second Amendment's guarantee. If so, courts are then tasked with evaluating or determining the appropriate level of scrutiny, and then simply asking the question of whether the restriction survives the appropriate level of means-end scrutiny. Now, what are the different options in terms of means-end scrutiny? We know that there are generally three, although there can be kind of gradients within them. Heller does give us some guidance on that point. Heller explicitly rejects rational basis review. We know that from the text of Heller. We also know that Heller rejects a balancing test that Justice Breyer proposes in his dissent. So with that guidance, most circuits believe that Heller allows for either intermediate or strict scrutiny. The question then becomes, how do you know which one to choose? Well, in NRA versus ATF, the court went with the lower of the two forms of scrutiny simply because that was one of the historically understood prohibitions, therefore probably an acceptable prohibition. But let's go back to this 922G8 that we saw in Emerson. It has come up again in several other circuits, particularly the 10th Circuit, the 8th Circuit, the 4th Circuit, and then most recently again in the 5th Circuit in a case called United States versus McGinnis, decided just this year. So of those circuits, 4 out of the 5 have applied means-end scrutiny, each one applying intermediate scrutiny for a variety of reasons. Some courts have believed that intermediate scrutiny is appropriate because the prohibition is only temporary. In Texas, for example, a typical protective order is going to have a duration of 2 years. Some courts have observed that people with an active domestic violence protective order out against them represents a narrow classification of persons that really isn't as large or doesn't really fall within the full scope of the Second Amendment's guarantee. Other circuits have reached the conclusion that this is not law-abiding behavior at all, because a person who is a domestic abuser is not a law-abiding person, and the Second Amendment really should only apply to the possession of firearms for all law-abiding purposes. So courts have kind of reached different paths gone through different paths to reach this conclusion, but all of these courts have applied intermediate scrutiny. The one outlier is the 8th Circuit in a case called United States versus Bena, B-E-N-A, in 2011, which didn't apply means-end scrutiny. Instead did a form of a historical analysis, simply asking the question, is there a historical analog for this type of restriction? And ultimately concluded that there was. Now, the contrast between the way Bena approaches it and then the way the 10th, 4th, and 5th Circuit have approached it, can really be seen in a very, very recent debate over what should the standard actually be. This was first described in a case called Heller 2 before the D.C. Circuit, in which now Justice Kavanaugh, at the time Judge Kavanaugh, wrote a dissent explaining that these circuits are applying Heller completely wrong. Justice Kavanaugh argued that Heller does not condone either intermediate or strict scrutiny. Instead, what Heller puts forth is a text, history, and tradition analysis to see if a prohibition on the Second Amendment's right to bear arms is permitted. So according to Justice Kavanaugh, if you read between the lines of Heller, sure, it rejects rational basis and balancing tests. But then if you look at the type of balancing test that Justice Breyer was proposing in his dissent, it was really a form of intermediate scrutiny. So to Justice Kavanaugh, all that would have been left is strict scrutiny, but the court didn't adopt strict scrutiny. Instead, the court talked about doing a historical analysis to understand the full scope of the Second Amendment, and also looking at historical prohibitions. So from this, Justice Kavanaugh has derived a standard that he proposed in Heller 2, that we look deeply at the text, history, and then for any analog, which he calls tradition, to the type of prohibition that's being challenged. In fact, Justice Kavanaugh's proposed approach has really taken on some steam and has some supporters. In fact, in United States versus McGinnis before the Fifth Circuit decided just this year, although the court did apply strict scrutiny, they did it consistent with the court's precedent. 2 of the 3 judges in that case wrote a concurrence asking for the Fifth Circuit to revisit its analytical framework and perhaps adopt something that like what was being proposed by Justice Kavanaugh. Similarly, in a recent case from the U.S. Supreme Court, New York State Rifle and Pistol Association versus City of New York, that's a case that was pending in the 2019-2020 term. Ultimately, the Supreme Court dismissed it as moot because New York changed its law. But you had 4 justices by name say that the standard that Heller put forth has been misinterpreted by lower courts, implying that at least 4 of the 9 justices believe that means-in scrutiny is not the appropriate approach to evaluating claims under the Second Amendment. So now we have these 2 competing approaches, text, history, tradition versus intermediate or strict scrutiny. Right now, by my count, for example, in the Fifth Circuit, 7 of the 15 judges believe it should be text, history, tradition. 8 of the 15 believe it should be intermediate or strict scrutiny. By my count at the U.S. Supreme Court, 4 justices believe it should be text, history, tradition. The other 5 probably believe it should be intermediate or strict scrutiny, although no one has said so per se. There are some really big changes ahead for us in the Second Amendment, how we approach the Second Amendment. And I think in the next few years, we're going to have a very big case that answers this third and critical question. Something to look forward to.